Mr Chair.
Potter Williams.
Mr Chair, there is no easy place for this debate to land because there's nothing more vexatious than the issue of harm that comes to our children. So I want to just acknowledge the Select Committee who heard the submissions on this particular piece of legislation because there were some difficult things to hear and it's a very sensitive conversation. So in that vein, that there is no easy place to land around this particular issue. That's how I actually want to structure my comments in this committee stage debate. When we look at the purpose, clause 3, there are two key phrases that are within the legislation. The first one is about reducing sexual reoffending. We had many submitters who came to the committee, Sir, and there were a variety of views, but if I can sum up perhaps the arguments on both sides when it came to that particular argument about reducing sexual offending. So some of the submitters said that this legislation actually has the ability to identify where potential risk can reside within the community. That's important. So potential risk can be identified and therefore it's easier for offenders to be taken in for questioning by police should another offence occur. So you kind of know in the community where there are some identified individuals who pose some risk. And it's easy for the police to be able to monitor that group of people, as long as they're placed in appropriate settings. And that's something I want to come back to later. There was another group of submitters, Mr Chair, who actually had another argument in that they felt that the significant amount of money that we're talking about, and it is significant, and I want to comment on that because when the Social Services Select Committee conducted the inquiry into funding for sexual abuse services, the result of that was an extra $10 million into the sector over 4 years. So we're talking about the difference between $10 million to support the sector for people who support victims of sexual offending and a significant amount of money, 146 over 10 years for this register. So there's quite a disparity there. And submitters said that they felt the money could be better spent on rehabilitation and prevention. That's the thing that I don't think that this register actually addresses, and that is the prevention of harm through sexual assault. The other thing that the second lot of submitters said was actually there are relatively low rates of reoffending. So that when you have a register of people that you know where they are in the community, they may not be ones who are likely to reoffend. And to also pick up on the point that our Greens colleague made about the notion of stranger danger, this register actually plays into those ideas around stranger danger. When we know that sexual offending, particularly of children, actually happens with people who are known to the family. By and large, there are much more people who offend when they are known to the family. And over a period of months, perhaps years, children particularly are groomed by these people. So we've got two arguments with regards to whether this piece of legislation actually reduces sexual reoffending. The other significant part of that clause is about reducing the risk posed by serious child sex offenders. And here I want to comment on two recent cases where the community has had a view about having sex offenders in the community, namely in the hut and also in Mangere, where the community has been very clear about the fact that they do not want sex offenders in their communities. They have felt that the placements of those offenders has been inappropriate in their community, whether it's been where they've lived, whether it's been where they've been able to access children close to schools, that kind of thing. So the community has, Mr Chair,
David Clinton.
Chair, I'd like to